Now we're going to look at the system that protects children. And I have a link on Moodle to the New York State Child Protective System. You can look further into the system and see what is available in New York State and the system. We're just going to talk here generally about how it works. I will add my 2 cents regarding practicing in this area. Generally, it is assumed that parents have the right to bring up their children as they see fit. There was actually a Supreme Court case that said it, Granville. The U.S. Supreme Court ruled that the Due Process Clause of the Constitution protects against government interference with certain fundamental rights, including parents' rights to make decisions concerning the care, custody, and control of their children. Now, that is a Supreme Court ruling. However, you have to take the ruling in the context of the case. And I do want to tell you that Granville was not a child abuse case. It didn't involve an abused child. What it was a challenge to Washington State's law that said the code permitted, quote, any person, I use that term, quote unquote, any person to petition the family court for visitation rights at any time and authorizes state superior courts to grant such rights whenever visitation may serve a child's best interest. So, on that, the plaintiffs here, or petitioners as they call them in family court, they were the grandparents. And they petitioned for the right to visit their granddaughters. Their son had died. And the girls' mothers didn't oppose visitation, but they objected to the amount that they sought to have the children. And the court ordered more visitation than the mother had desired, and she appealed to a higher state court in Washington, who then reversed the decision and dismissed the petition. And that was the state Supreme Court. And in affirming, the court said it was unconstitutional to infringe on parents' fundamental right to rear children, reasoning that the federal Constitution permits a state to interfere with the right only to prevent harm or potential harm to the child. And it also said that the statute does not require any threshold showing of harm, and it sweeps way too broadly by permitting any person to petition at any time, with the only requirement being that visitation serve the best interests of the child. So technically under this, anybody, like the next door neighbor, could petition for visitation. So the grandparents appealed to the Supreme Court, and the United States Supreme Court agreed with the dismissal with the lower court. So that's what the case was about, but it is still recognized as a fundamental right that parents get to make the decisions concerning the care, custody, and control of their children. And certainly a lot of issues rise relative to parents who don't seek medical attention for their children because of religious practices. That's a pretty big deal because you have the constitutional right to practice religion too. So those always kind of butt heads outside the scope of this class. In 1974, Congress passed the Child Abuse Prevention and Treatment Act. The federal system doesn't have its own court system prosecuting or looking into the rights of children. That is left to the states, but the statute provides federal funding to states to bolster their services for the maltreatment of children. And states, like I was getting into, they have their own each one has their own child protective system. And I put the link for New York's overall website. But technically they're run by individual counties, and each county has their own. Clinton County, the Department of Social Services, has the Child Protective Services in it. That's one of their departments. And the courts have set forth guidelines for the removal of a child from parents, as well as guidelines for terminating altogether the parental rights that they have. The courts have that power to do as well. Children in these proceedings are provided an attorney. Guardian ad litem is the general term. Not all states use that term. In New York, we refer to the attorney as the attorney for the child. We used to call that person a law guardian. And most of the time, this guardian ad litem is an attorney, but that's not always the case, and that's not necessarily true in every state. I think New Hampshire the guardian ad litem doesn't have to be an attorney, and I think that's the case in some of the southern states as well. Procedures vary from state to state for investigation and reporting, as well as the process through the court system. But generally, I like the chart in the book, page 199. That's an accurate reflection of the steps taken from inception when CPS gets the complaint or the tip, or however it comes in. It can come in a number of ways. The inception to disposition. If the allegation of abuse is confirmed, the child may be placed in protective custody, but that's not always the case. They get a referral. At the inception point, there'll be some sort of referral that CPS gets. Then they do an investigation, and they can determine, one, that the claim was unfounded. That's the terminology we use here. It's unfounded. No further action is taken. It's gone. It's sealed up. Nobody knows about it. And the other term is if they see that there is some abuse or neglect, it will be deemed indicated. Their investigation will deem it indicated, and then they may refer, not necessarily go to court yet or remove the child. It depends on what it is, but they may refer services to the parents for them to follow, and CPS will continue to check up on them to make sure they're doing things. So if, their house is not well, and I don't mean, when I say not well kept, we're talking about it's dangerous. There's light sockets that are, hanging out, and a child could be electrocuted, the ceiling's caving in. It's disgusting. Like I've been in homes that were full of animal feces. So there are times where if it can be cleaned up or if there can be services provided, there won't be a court proceeding. But if it's over and above and it's serious, like the child has been hospitalized for being physically abused, or there's clear, abuse and neglect happening, they will petition the court. CPS will petition the court to seek removal. Actually, they will remove the child, and then they'll get their order and immediately for that to happen. They'll apply for it. They'll have the removal instantaneously, and then the case will be back in court within a couple days. Most state statutes will require this court notification promptly or immediately if the child's going to be removed, and it's usually extremely quick, 3 to 5 days. And that's only if there's like a weekend or a holiday that ties it up. I think it's 3 days max. And when an abuse and a neglect petition is prosecuted, there's this, let's call it advisement hearing. It's not called that here, but that's a general name for it. Here they'll call it an initial appearance, where the court advises the parents. It's actually a little bit like an arraignment. Now we're gonna talk criminal court, and this process in family court seem to kind of cross each other. But we'll call this advisement hearing. And at this advisement hearing, this is where the judge will say to the parents that they have rights. Usually they have a right to an attorney. They have a right to know what's being alleged against them, what they're saying, what the abuse is, what the claims are of neglect and abuse. And they have the opportunity at that point to deny or admit, versus pleading guilty or not guilty in a criminal case when you're before the judge. They have the opportunity to say whether they admit to what's happening or denying it. Most deny it. I didn't do that. I didn't do it. And then the case will continue to the next step, which is a pretrial conference to determine if a resolution can be reached. There are various outcomes, but usually requires the parents to admit they neglected or abused the child, which is extremely hard for them to do, especially in cases where there's, drugs involved or excessive alcohol. Parents don't want to admit that, they were neglecting their child. They represented a child in an abuse and neglect case. She was 6 years old, and she found her mother laying on the bathroom floor unconscious because she had OD'd. And the 6-year-old ran to the neighbor to get help. And this wasn't a first-time thing. Like, the child would walk in and find her mom doing drugs in the living room. There'd be needles around the house. And getting mom to recognize not only that she was doing these things that were neglectful to her child, that she didn't mean to, like she, deep down she didn't mean to, but she couldn't say that she had a problem. So in those instances, you don't leave the court no choice. But nonetheless, it is very hard for a parent to admit sometimes their conduct. So if the case does not settle, types of settlements include the parents agreeing to promote, agreeing to do programs or treatment, if we're talking about drugs that are involved, or agreeing that the child live with a family member until they, clean up the house or clean themselves up or get the programming that's needed, versus the state, taking custody and putting the child in foster care. That's always how things get agreed to, because the case will continue along, whether it's settled or whether there's a trial. If there's an admission of neglect and abuse or both, the court's going to keep, and the child is now outside of the parent's custody, the judge is going to keep track of it to determine whether or not the children should be returned to the parents. So if it's not settled, the state has to prove the allegations of abuse, and they have to do that by they have a burden of proof. In a criminal case, you've probably heard in a criminal case, if you watched any criminal shows, beyond a reasonable doubt. It's a high level of burden of proof. This one is not so high, but it's the next level down. It's clear and convincing evidence. So it's a high standard. It's higher than a lot of civil cases, but it's lower than the criminal case. And in a family court judge hears the case, there's no jury involved in these kinds of cases. Now, I want to point out that the book is wrong regarding the penalty the parents can get if they are found to have abused or neglected their child. This is not a criminal case. They don't go to prison. They're not found guilty. While abuse and sex abuse can lead to criminal charges, even neglect can lead to criminal charges. It's called endangering the welfare of the child. The conduct can certainly lead to a prosecutor to file criminal charges against a parent, but those are separate than the removal of the child from the custody and care as a result of the abuse. The two cases usually happen at the same time. There will be criminal charges and then filed by the district attorney, and then Department of Social Services, CPS, will file a neglect abuse petition in family court. But they're two separate legal proceedings, and only the criminal case can the parent be subject to prison, being put in prison. So what we're talking about here, though, is taking the child away from the abusive situation. It is not to punish the parent, but to protect the child. That's the way this system works. It's not a criminal system. It's not about punishing the parents. It's about protecting the child. So if there's a finding, the court then has to have this, what's called a dispositional hearing. It's the dispositional stage, kind of like sentencing. This is where the court is going to lay down what the parent needs to do in order to be able to petition the court for the child's return to them, or allow the child to be returned to them. Social Services, or CPS, provides a case plan to the court that guardian ad litem representing the child will advocate for the child's position, and the parents' attorneys will each have a say. And then the court has to decide, has to weigh these things and decides what happens next. Usually it'll be depending on what the allegation or the finding of the abuse and neglect are about. But if there's going to be services that are involved, the court, treatment, if we're talking about that mother that I just mentioned, has to do some treatment. Maybe the court will allow for like visitation with the child that's supervised. Like she can't have the child alone. Those sorts of things. And it'll come up on the court's calendar for review of compliance. So, but the ultimate decision the court makes is what's in the best interest of the child. So if the parent cannot comply, or if this is a serious abuse case, like let's say sexual abuse of a child, let's say we have a case that involves sexual abuse of a child by a father, who is then prosecuted by the district attorney, and then he's sentenced to prison. There's nothing to rehabilitate. There is no programs. The family court is ultimately going to terminate his or her rights, depending on it's a father, so his rights, depending on how long he's going to be gone for. But in a sex abuse case and there's a conviction, there's usually no contact with the child. So ultimately, the father faces his parental rights to be terminated. Now, if the mother knew that this was going on, she is also subject to losing her rights to her child. There's no programming that's available for something like that if you have allowed that to happen. So the outcome could potentially be having her parental rights terminated. But kind of getting way off base a little bit, but I don't think the book fleshes this out as clearly as it should be, and it seems to cross paths with the criminal cases. So I already gave you the example regarding successfully getting, so if there's programs involved in cleaning up. So now let's talk about the in court. Because you need a witness, right? And in an abuse case, a child who's not the best witness, but the child who was abused. So this is a very significant problem that is associated with abuse cases because a bunch of reasons. One, the trauma. The child must go through now a court hearing, even after being abused. And sometimes the child's too young. They get confused, or they get scared. Even teens. I've represented teens who are like, I am not going to go on the stand. I don't care. They refuse to go on this. Doesn't want to face, their accuser. And being a witness isn't fun as an adult. You're cross-examined by an attorney, sometimes by the judge. In family court, it's several attorneys. So you got mom's attorney, you got dad's attorney, you got child protective services attorney, you got the attorney for the child. So, it can be very traumatic for the child. There's also the questions about accuracy of the child's reporting. Some get encouraged. Some are guided, not just by the system. The prosecutors meet with their witnesses and help them through their testimony. With a child, a lot more coaching, I say that in quotes, coaching goes on, but not by the system, by parents too. You can have a disgruntled parent, and I have seen parents using this system for their own revenge, especially in divorce cases, separation. Parents want to get a leg up in family court, so what do? They call CPS on the other parent. They try and get the child to say that they were abused by the other parent. So that happens a lot. It's mentioned in the book. But on the other hand, there is the belief of a child over a parent, especially an affluent parent. That's another problem we have, right? Who are we going to believe? If you have a affluent parent and there's a child saying I was abused, maybe the parent's like, oh, the child's got problems, doesn't know what they're talking about, that sort of thing. You'll see that in Luke Fox's story. That's this week's forum post. or a parent who knows the system. They've worked in the system. There's a well-known child abuse case. It's mentioned in the book. I want to mention it here because it's fascinating. You should, if you got 5 minutes, Google it because it's very interesting. It's not a family court case. It is a criminal case. And it, like I said, it's not a case brought by CPS to remove children from parents, but rather a case against a preschool. It's the McMartin preschool. It was so bizarre. You can, I don't even think I'll do it justice. The book doesn't do it justice either. So Google it. 6 trials. I believe they've gone through 6 years, 2 different trials. But basically it came down to the complete lack of reputable evidence against, these are teachers and workers at Macmillan Preschool, and with every indication that the child had been coerced and manipulated into their testimony. But the prosecution nonetheless kept proceeding against them. It lasted over 6 years and cost the state of California like in the millions of dollars. And they were claiming that, they were doing satanic, devil worshiping things on the children, and it involved the children with dead animals. It was bizarre, but there's a lot of information on that particular case. So what do we do to overcome having children in court? The Supreme Court says that it is okay for children not to be in the courtroom, despite the fact that the accused has a constitutional right to confront their witnesses. So there have been some ways that they get around having the child in court: videotaped statements, some recordings. They've allowed television, where the child appears on a television. They've allowed physicians and mental health professionals to testify about statements that the children said to them. Now, there's always a question of, you may have heard this term, hearsay, right? You tell someone what somebody says. This is, well, they told me this, and you repeat it. It's technically not allowed in court. In family court, there's a lot more discretion on how it's allowed and what's allowed. So some of it comes in, but blatantly is, the child told me this and the child told me that. But when we're talking about legal professionals, they're usually, that information is out and available for them to talk about, because they talk about it in the terms of, they had to tell me this because I wouldn't have known how to treat them. So these are statements made through the course of treatment. In order for me to diagnose, they have to tell me something. So that's allowed. Other ways that they're allowed to testify in court is a viewing screen, where the if it's a criminal case, it's a defendant, but if it's family courts, the accused, the respondents, the parents, they can't see. They can see, but the child can't see them. And that helps. New York has used all of these different systems, as well as in person. Surprisingly, there are some children who can testify confidently and very young. I saw an 8-year-old, right before the whole COVID hit back in March. I think it was a trial in February, where an 8-year-old testified to the sexual abuse at the hands of a step-parent. And that there was a conviction, and the evidence was primarily the 8-year-old's testimony. So statements and having the abused child in abuse, neglect, and delinquency, how does it tie together? Yeah, best I can't. You're not surprised that the link between maltreatment and delinquency is supported by a number of criminologists, and the theories, as I have intertwined already. In this discussion, studies of juvenile offenders have confirmed that between 70 and 80% may have had abusive backgrounds. The literature suggests that victims of abuse are often associated with subsequent episodes of delinquency and violence. In a series of research studies, criminologist Kathy Wydum identified a cycle of violence in which physical abuse by parents and caregivers is a direct cause of subsequent violent behavior among the youth. Kids who were abused are then likely to grow up to be abusers themselves. And then obviously their kids grow up to be abusers. Like, it's a never ending cycle of abuse and violence. They are significantly more likely to be arrested for violent crime sometime during their life. The abuse-violence link can take different forms. Some violent offenders have long histories of abuse and neglect, and this condition is a direct conduit to the personal involvement in violence. Others develop post-traumatic stress disorder in the aftermath of their abuse. Their subsequent violence can be linked to the emotional upheaval brought on by the history of personal traumas, whatever its form. So whatever its form, the abuse-violence association with it is quite significant. Of course, not all abused children become violent criminals. Many do not, and many violent youths come from what appear to be model homes. Whitem herself finds that the majority of both abused and non-abused kids do not engage in antisocial behavior. So this kind of shows that more research is needed to clarify the association. Being the target of abuse increases the likelihood of arrest as a juvenile by 59%, as an adult by 28%, and for a violent crime by 30%. So this discussion of the discussion of this child abuse and neglect is going to pick up in the video in this week's assignment, which explores more of the effects of abuse on children.